Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. So, this is a Megan Thee Stallion versus Milagro Gramz update. There have been a few filings since we last spoke in regards to Megan submitting her admitted complaint to take care of the cyber stalking information. She had to pretty much further explain as to how Milagro was stalking her. And she had to update because in her First Amendment complaint, she just told the court to reference. I believe an affidavit without further explaining as to how Milagro was stalking her. So since then, she has submitted to the court the Second Amendment complaint, and we went over that. Now, anytime you amend a complaint, once again, you have to send it to the other party and they have to respond to it through a form of answering. And so they actually answered it. And when I say they, Milagro actually filed an answer. And that's what I want to go over with you guys today, the answer and the other filings that have been docketed, as well as Milagro's half apology that she issued the day after a motion for a protective order has filed. And I'm going to explain all of that later on in this video. But let's just hop right on into her. Milagro's answer to the second amended complaint. And once again, I'm not going to go through this, but I just want to kind of give you guys an idea of what Milagro has admitted to and what she has denied. Normally, any person who has responded to a lawsuit, they are going to deny majority of the allegations that is made in the complaint. All right, that's just kind of standard. But there are some things that you admit to, like your name, the jurisdiction as far as where you live, and just certain things throughout the complaint. Not every, but certain things. And so for instance, for the nature, and I pulled it up this way so you guys can have a view to see, okay, what is it that she actually denied? So under the nature of the action, she has denied all of those claims. I'm not going to go through all of this. Once again, just kind of go back to the last video, and you'll catch me going over the Second Amendment complaint. But this pretty much just kind of gave us a synopsis of what this case is about, how it started, and pretty much how they ended up here today in court. So as far as the nature of the action, she pretty much denied all of those claims. As far as the party goes, once again, she it's funny, it says without knowledge, therefore denied to number 10. So it says Megan P, a performance artist, also known as Megan Thee Stallion, is a citizen of Florida who permanently resides in Miami, Florida. I mean, she doesn't know this, so therefore that's why it says without knowledge, therefore denied. But she did, admit to her being a permanent resident in the state of Texas. Um, Now, going down to the factual allegations, because remember, there were counts of defamation, the alter of the depicted deep fake video, the infliction or intentional infliction of emotional distress, and cyber stalking. So those were the four counts that were within the factual allegations. So for the majority, Milagro, once again, she denied, with the exception of 23. So paragraph 23 reads that defendant was present in the courtroom for the entirety of the trial, including Miss Pete's testimony, and she admits that she was present in the courtroom during the duration of the trial. On paragraphs 26 and 27, she admits in part and denies in part. 26 reads that defendant is an online social media personality. Here it states that she admits she has social media accounts, but because the social media personality is undefined, she is denying that. Because what is a social media personality? And then once again, she denies and admits in part on paragraph 7. that reads, I'm going to read what the complaint says versus what she said. So, defendant controls and operates X, formerly Twitter, accounts under the usernames Mobs World, Ninja Girl, and Milagro Grams. Um, Instagram and TikTok accounts under the username at Milagro Grams, a YouTube account under the username at Mob Radio, and a station head account under the username Milagro Grams, collectively all known as her social media accounts. A defendant has the power to determine the subject matter and the specific content that is published on her social media accounts and to remove or refrain from publishing content if she chooses. Defendant is the sole speaker, writer, and or editor of every post on her social media accounts. Collectively across the social media accounts, defendant has over 100,000 followers. So Milagro states that she admits to operating numerous social media accounts at one time or another. Defendant further admits that she has editorial discretion on what is published, subject to the terms and conditions of the specific forum. Now, defendant also denies that she is the sole speaker, writer, and or editor of every post on her social media accounts, meaning that she more than likely has other people that speak on her accounts, I guess, write or makes posts under those accounts and edits those accounts. I highly doubt it, but I mean, it is what it is. If she does have a team, then that does make sense. Um, all the other paragraphs 28 through 41, um, she is denying. So, like her relationship with Mr. Peterson, being in contact with Mr. The dad as well as the son. Oh man. The campaign of years long of harassment against her, she denied that. She denied in regards to the promotion of the deep fake video. Let me see, 42. She does admit that she has a screen username of Mob's World. But any other part of this paragraph she denies. She admits that she did press the like on the X post with the deep fake video. Let me see what 49 says that. Yep. So she said she admits that she posted a video on June 9th, 2024. So paragraph 29 reads that on the next day, on June 9th, 2024, the defendant published a video on her YouTube account to her more than 74,000 subscribers that addressed her "Go to my likes" X post related to the deep fake video. So she does admit that she posted a video. Wait, admit that defendant. Well, she admits that she posted it. It says right here, admit that defendant posted a video on June the 9th. Oh yeah, okay. So it was a video that she said go to her likes for the related deepfake video. 50, she said that YouTube video pretty much speaks for itself. She denied all the other allegations. So everything else is denied. And then she has also entered in her affirmative defenses. Let me see. So let me get out of this and let's see what her affirmative offenses are. All right, so it says, as for the first offense, for the reasons set forth in defendant's motion to dismiss first amended complaint, defendant asserts that the claims against her fail to state a claim upon which relief can be granted. So she is still saying that um, Megan's petition, both first and second amended petition, still fails to state a claim, even though the court came out with their last pleading stating that Megan stated her claim. As for its second defense, plaintiff's libel or slander claim against the defendant should be dismissed on all of the alleged defamatory statements attributed to the defendant are at best non-actionable expressions of pure opinion and or rhetorical hyperbole and or truthful statements. Once again, and see, I am really questioning the attorneys on this because the judge clearly came out with their opinion in regards to the motion to dismiss Milagro's motion to dismiss, and found that um, Megan did everything that she was supposed to do. The only thing she had to correct was elaborate on the cyber stalking. So I don't know why they are entering the same affirmative defenses. It doesn't make sense after the court has already said that Megan did state her claim. The statements were defamatory. Um, okay. As and for its third defense, plaintiff's libel slander claim against the defendant should be dismissed as the plaintiff is a public figure and as such failed to establish actual malice by clear and convincing evidence. The court did find that she did establish clear and convincing evidence. As a fourth for the fourth defense, they're saying that plaintiff has failed to establish that any of the alleged defamatory statements caused plaintiff actual damage. She also states in the fifth defense that plaintiff failed to provide statutory notice to defendant or the opportunity to retract any statement prior to the filing of the instant action. Um, in the sixth defense, defendant's words and actions are protected by the First Amendment of the United States Constitution and Article 1, Section 4 of the Florida Constitution. Seventh defense states that count 2 fails to state, and this is for the deepfake video, fails to state in action for violation of Section 836.13 of the Florida statutes, as defendant did not promote a deepfake video within the meaning of the statute. Furthermore, the statute is overbroad and infringes on defendant's First Amendment rights. The eighth defense, count 3, was the intentional infliction of emotional distress. Milagro is saying that that count fails to reach the necessary threshold of outrageousness required under Florida law to state a claim for intentional infliction of emotional distress, and fails to establish the requisite level of malice required under the First Amendment as mandated in Snyder versus Phelps. In her ninth defense, she's saying that the cyberstalking claim fails to state a claim for cyberstalking under the Florida law. And furthermore, injunctions are not available to stop someone from uttering insults or falsehoods. Um, Whereas or wherefore, having answered plaintiff's Second Amendment complaint herein and have raised affirmative defenses thereto, defendant Cooper requests that his action be dismissed and that the defendant Cooper be awarded her cost in the defense thereof as allowable by law and attorney's fees uh, pursuant to. Look at this. Yeah, I got a spell check, man. Or uh, pursuant to Section 836.13, paragraph 5C of the Florida statutes and such other relief as the court deems appropriate. Why these affirmative defenses were included, again, after the court has already stated that Megan has already met the burden of proof, is beyond me. Hey, anywho's, we're gonna carry on. If y'all are lost as to what I'm saying, I'm gonna put that video where I read the court's order regarding each count that Megan, uh, stated in her petition, because this doesn't make sense. The court has already stated that she stated her claim, that she has actually provided clear and convincing evidence in regards to, the claim, all of that. So this doesn't make sense. It doesn't make sense at all. Um, Now going into the protective order part. So they have gone through the process of amended the complaint, and Milagro has answered. Now they are into the discovery phase. And so anytime, and you've seen this like in the Sean Combs case and some of these other cases, that when there is material that are very sensitive, they don't want, it to be public knowledge. Now, for when it comes to discovery itself, That's not something that we are going to physically see, because that is something that is exchanged between the parties and their counsel. Now, in the event somebody is submitting a declaration and they're wanting to use some items, whether it's information or documents or whatever the case may be, still images, video, whatever the case may be, and they're submitting that with their declaration or affidavit as proof to support whatever motion they're filing, they may use stuff that was obtained in discovery. And so when they do that, when they are filing their declaration or their affidavits and they're attaching these exhibits, the exhibits have to be protected. Now, so what they did is they came up with a joint motion to submit to the court and asking the court that certain material, if it is presented as supporting information to a declaration or to a motion, or if it's going to be used later on in litigation or at trial, that they have certain protections for that. And so both attorneys, Milagro and Mega's attorneys, got together and say, okay, these are the rules, these are the procedures that we are going to follow to ensure that certain information or documents or whatever the case may be protected during the duration of this litigation. And so that is what we have here. So both Quinn Emanuel and Painter Law, is the co-counsel for defendant, is coming together and they're saying, okay, let's go and unite the people. They're saying, okay, let's go ahead and let's come up with this so that we can continue to move on with this litigation. So this is just a motion. Okay, it hasn't been granted yet. All right, here's the proposed order. So this is the stipulations. I'm not going to go through all 21 pages, but I am going to kind of sum it up, and I already kind of did it. So it's going to be in certain categories in which certain information, now not all information may be considered under the protective order, but majority of them are. And they're going to have them placed in pretty much two categories, whether it's going to be confidential or highly confidential with only the attorney's eyes only, because anytime you're doing discovery, like I said, you're exchanging it to the other party, right? But there may be some things that are not going to be viewable to the plaintiff or to the defendant. It's only going to be viewable to the attorney, which why they say it's going to be highly confidential and the attorney eyes only. So with confidential information or items, it says information regardless of how it is generated, stored, or maintained, or tangible things shall include non-public, sensitive business, proprietary, or sensitive personal information, including personal financial information, including electronically stored information, documents subject to separate confidentiality, obligation owed by the producing entity to a third party, or other information, or which the producing entity otherwise believes in good faith to be entitled to protection under the Florida or federal law. So let's say that it's personal information, bank statements, right? That's information that cannot be viewable to the public. It just all depends on what's on there. You see what I'm saying? So it could be marked as confidential. So that way, if they're using it as an exhibit, then it might be protected um under the confidential or the what do you call this, protective order. It may be protected under the protective order. So you might see certain things redacted. Like you're not going to see Malagro's address or her bank account information or any other information besides the information that they want to be shown. And that's vice versa, same with Megan Thee Stallion. Okay. Then we have the highly confidential, and that goes for anything that's electronically stored, anything that's tangible. It can be information, business information, strategic, proprietary, financially commercial sensitive business information, medical information, or information subject to confidentiality restrictions, trade secrets, or other similar information. So they want to just make sure that everything is covered. Okay. Um, Now, this does not only apply to how defense counsel or plaintiff's counsel handle this information or items. This also goes for any other party, whether not necessarily party, but other people like the court clerk, the court reporter, the videographer during depositions. It could be for how the experts, because you're definitely going to have experts, and some experts do require for certain information to be forwarded to them so that way they can review things and they could go over. So they still have to follow certain information as well. Non-party people, anybody who's in the party, the producer party, so the custodians that are over the information or the items that's, being sought, pretty much everybody, every single person who is looking at anything that is produced, whether tangible, whether certain items, videos, photos, information, whatever the case may be, they all have to follow the procedures and stipulations of this protective order. So nobody is out, okay? Even the judge, okay? So if they're producing stuff in court, if there's a trial, they would still have to follow the same guidelines under this protective order in trial. All right. So, as of right now, this is only a proposed order because, as you can see, the judge has not signed yet. So, this still has to go before the judge. And if he approves, he or she, if they approve of this stipulation for the protective order, then they will sign it and it will go into effect. Okay. But like I said, this is because they have now entered into the discovery phase. I'm pretty sure that they already have certain documents. But going first, since the hold on, I'm trying to exit out of this. So since we have submitted the second amended complaint, Milagro has answered. Now we are entering in discovery where a lot more information is going to be gathered. A lot more items are going to be gathered. Videos, photos, phone conversation, bank statements, whatever the case may be, is now going to be gathered. So they do have to protect that information, especially from the public. Because if you want her to have a fair case, then definitely. But they're about to pull every and anything if they have not already done so. So, oh, and this is what you know what? I forgot. I forgot to go to her, whatchamacallit. So that was already taken care of, right? So that was filed on the 21st. I want to bring you guys' attention to Milagro's apology. She came out with she issued an apology. Um, do I think it was sincere? No, because and y'all definitely could go to her Twitter page and kind of read on what she has posted since then. But my issue with this is the apology, just as she stated Megan's name for the last couple of years in regards to this, she could have put a name on this post. That's my personal opinion, but I'm saying if you hashing it out over somebody and you were directly talking to them, for the past couple of years, and now you issue an apology, but you're not directing that apology to that person, then is it really an apology? But here is what it reads. Something significant needs to be addressed, but to be as sensitive to the circumstances as possible, I don't want to make anyone uncomfortable by speaking directly to them. When I use my platform to express my thoughts and ideas, I hurt someone. My lack of regard for how my words could have affected the people associated with my topic of discussion led to pain, and that truly was never my intention. There is never a day where I would want my behavior to cause someone to want to remove themselves from this life. Ever. I have never been offered nor accepted money or anything else to speak ill of anyone. The platform that hosts any related videos were not and are not monetized, so I did not make a profit from these things. I was overzealous in the pursuit of what I thought the truth was, and the reality is that doesn't make anything a fact. I apologize and I am deeply remorseful for the harm I've caused. And baby, when I say these people are eating her up in her comments, it's ridiculous, bruh. Then she goes on to say, this case is still very active, so under no circumstances do I believe that expressing my thoughts here is going to make everything go away. It's damned if you do, damned if you don't with this internet ish, so there would be no way for me to please everyone. I just thought that it was important to me to come to the same space where I said other things and express my triteness. The majority of people reading this don't know me personally, so how could I convince you of my sincerity? Exactly. So, for the ones that truly know my heart, hurting someone was never and will never be what I to do, set out to do. And that concludes this video. So, y'all let me know what y'all think about that apology. After reading the documents, knowing that, okay, now we're in the discovery phase where we are now collecting the remainder of evidence, we are subpoenaing, we are finding out certain things. Do you think that this apology came in reference to her knowing what is about to be revealed? Do you think that her apology was sincere? Do you believe that she should have mentioned Megan directly since that's what she was doing for the past couple of years? Y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.